Okay, I'm going to call this meeting to order. That means our friends from the media have to leave with their cameras, and thank you very much. With that, we're at the Standing Committee on Justice and Human Rights meeting number 30, as of the order of reference of Monday, April 28th, 2014, Bill C-13, an act to amend the Criminal Code, the Canada Evidence Act, the Competition Act, and the Mutual Legal Assistance in Criminal Matters Act. We are televised for the first hour, and we have the pleasure of having witnesses from the Office of the Privacy Commissioner of Canada. Mr. Therrien, welcome, Commissioner, and you can introduce your guests. You have 10 minutes, and then we will go to questions and answers. The floor is yours, sir.
Merci, Monsieur le Président, membres du comité.
Thank you very much, Chairman, members of the committee. Good morning. Thank you very much for your invitation to present our views on Bill C-13. To do so, I have with me this morning Patricia Cossem, Senior General Counsel, and Megan Brady, Legal Counsel. Today I will be looking at the cyber intimidation component and also the elements that introduce new investigative powers, as both aspects implicate privacy. From the outset, the OPC unequivocally welcomes the government's taking action to address online bullying and abusive use of intimate personal images. This is a pressing social issue that is of serious concern to Canadians. It is clear that the Internet use has shifted many of our traditional views about privacy. Better education, legal reform, and public discussion must all play a part in addressing the problem. We feel that a holistic approach is needed. It should include public awareness, such as the government's new Stop Hating Online initiative, as well as a strong emphasis on digital literacy education. It is important that children, parents, and teachers all have access to educational resources that help explain online risks and teach responsible use of technology and ethical behavior in online interactions. The government has signaled a commitment to digital literacy as part of its recent Digital Canada 150 strategy, and we would like to see continued dialogue and outreach to youth and educators as part of that effort. Cyberbullying clearly represents grave risks to individual dignity and privacy for all citizens who use social networks and communication online. We believe, therefore, that the criminalization of non-consensual distribution of intimate images and extending existing criminal code provisions related to harassing communications sends a clear signal. We need to ensure that cyberbullying carries serious consequences. That said, there are still clearly some complex privacy questions that are attached to many of the proposed measures, particularly those concerning some of the new investigative powers. We agree that the laws need to be modernized, but we have concerns about some of the specific proposals contained in this bill. Given the technical aspect of these amendments, my office has provided you with a written submission outlining these aspects in detail. Let me now summarize our main concerns very briefly. I would begin by reiterating my view that given the complexity of the issues you have been presented with in the course of your study, I would recommend dividing the bill into its constituent parts. From a privacy perspective, the offence provisions are largely uncontroversial and could be quickly dealt with by the House and then sent on to the Senate for review. On the other hand, given that sensitive personal information and significant police powers are at play, the lawful access components deserve very close scrutiny and would benefit from a focused and targeted review.
Thresholds for authorizations. Accessing data is significantly more intrusive than its preservation. While reasonable suspicion may be an appropriate threshold for preserving data, we believe that Parliament should closely scrutinize the proposed threshold for judicial authorization to access certain data. The divergence from the constitutional default of reasonable and probable grounds requires full explanation and a justification by government and merits a cautious approach. There are a wide range of new powers attached to Bill C-13 under which sensitive information would become more accessible to law enforcement, and a wide range of other governmental authorities at a lower legal threshold of reasonable suspicion. Transmission data provides a useful example of how authorities can obtain sensitive records via a reduced legal threshold under the new regime. Reasonable suspicion to access transmission data uses the precedent of the standard currently required to use a dial number recorder, or DNR. However, the information and records comprising transmission data, as it is defined in the bill, can be significantly more revealing than a record of telephone calls. We believe that suspicion is too low a threshold for such potentially revealing information in a digital era when every transaction, every message, every online search, and every call or movement leaves a recorded trace. As a result, we suggest that the bill use the traditional standard of reasonable and probable grounds to believe for the provisions under which access to information would be granted. That is the standard which should hold until a more compelling case for the use of a reduced legal threshold is presented and thoroughly examined. As a second concern, there is the broad range of authorities who can rely on these powers. The investigative powers and provisions in C-13 see both peace officers and public officers at all levels of jurisdiction in Canada broadly empowered with a whole range of new techniques. While many law enforcement and security agencies have robust accountability mechanisms, other government bodies implicated by this definition have no dedicated review and no transparency requirements. We find this to be of particular concern. Thirdly, there is the key question of legal immunity. Bill C-13 contains an amendment specifying that a person or organization enjoys legal immunity should they voluntarily preserve data or provide a document at an investigator's request without court authorization. We are concerned this broad language could lead to a rise in additional voluntary disclosures and informal requests. This is of particular concern with private sector companies that are otherwise prohibited from disclosing personal information without consent under PIPEDA or substantially similar legislation. In essence, this could amount to permissive access without court approval and oversight. Ultimately, then, we believe that Canadians expect that their service providers will keep their information confidential and that personal information will not be shared with government authorities without either their express consent, clear lawful authority, or a warrant. Enfin, Monsieur le Président, se pose...
Finally, Chair, there is the question of accountability and transparency mechanisms for new forms of surveillance. There are no requirements in the bill to report on the extent of the use of any of the new powers. This is certainly of serious concern, especially given the range of officers who can exercise these powers and the possible effects of extending legal immunity. In many other jurisdictions, ongoing reporting is part of the oversight structure, and we believe Canada should have similar ongoing measures for reporting. Thank you for your attention, and I do look forward to your questions. Thank you.
Providing your notes in writing to us, so every committee member has it. So our first questioner from the Democratic Party is Madame Boivin.
Merci, Monsieur le Président. Merci, Monsieur.
Thank you, Chair. Thank you, Commissioner, for being here this morning, and thank you to the people from your office. You probably had more time to read C-13 than you, but I certainly do appreciate your report on C-13. First of all, I would like to see whether or not you have the following impression. The Supreme Court is to hand down a ruling on Friday in R versus Spencer. Do you know what kind of impact that may have? Well, I would ask Madame Boivin and Madame Cossin to answer your question on our behalf. Thank you. The ruling in the Spencer matter is to be handed down, it appears, this Friday, and this should shed some light on the parameters of 36.1 on the Privacy Act, or PIPEDA as we know it. And it will be interesting to see what the parameters are, what the requirements, the exigencies that will be established with respect to a disclosure without mandate of any personal information to the police. And that will clarify 3CP.1 and what exists already in the criminal code. So it is relevant in that the new clause that will replace the existing one will also fall under the decision of the Supreme Court. Thank you. Secondly, since in the Commissioner's office, I'm sure you have analyzed a C-30. How does C-30 compare with C-13? Well, specifically, we are very happy to see that there is no longer a clause that allows for access to personal information without a warrant, and in particular what we call subscriber data. We are happy to see that this is something that is no longer on the table. That is an improvement, of course. And though we do have some caveats with respect to what's in C-30 and is in C-13, but I do believe that the Commissioner has set out our concerns very clearly. In addition to your application or your request to us to have the bill split, the government the government's response has been that one depends on the other. You can't have one without the other. Cyberbullying and the distribution of intimate images. Police will need these new modernized powers. To my mind, I think there should be a greater in-depth study about this bill as to whether or not it should be split. There should be witnesses and so on. My own concern is this. I am not necessarily a specialist in areas of access to information and the transfer of information concerning those people who appear before the courts. I think really what we're dealing with here is a very specific, restricted study about criminal matters, and it may have, though, an impact on other persons. This is my concern about this component. Do you share that concern, or can you make any comment about this very large question mark that I have in my mind with respect to the second part? Chair, our comments fall in line with the question that Madame Boivin asked. I heard Minister McKay say, you can't have one without the other. They go hand in hand. So if I understand correctly, to have concrete results, you have to have investigatory methods that will provide for that result. So I agree that, and the Commissioner's Office is in agreement with the modernization of the statutes with respect to investigations in an era where you have technological devices like the Internet are used. But we share, though, the approach that's being taken with respect to the legislation, but we do have concerns that are attached to the specific action that is cited in the Act, because the technical methods, the technological methods are very detailed and very specific. We don't want to have excessive delay in experts looking at the matter in hand. We want parliamentarians to be certainly aware of the concrete affairs, the concrete results, rather, of the matter that is presented to them. We want investigatory methods that are useful but will not have a negative effect on Canadians. I don't know if you have read this, but there are many newspaper articles that are out, not just here, but all over the world about these matters. Maybe I'm mistaken, but it seems to me that certain suppliers of the Internet, of telecoms, are trying to protect their clients, and there is a bit of a tug of war here between the government's interests, other governments as well, but the government of Canada in particular, and the suppliers, and what is being organized elsewhere to protect the customer's interest. Have we, through C-13 and through other methods, have we been able to protect the information of Canadians, or have we been too lax? Do you have comments? I'll just say briefly that the government is producing legislation that is intended to meet the needs that exist, that is to say, modernize the investigatory methods. That seems very legitimate to me. But we do nonetheless have those concerns that I have expressed. I would encourage the committee, I would encourage the House to see that privacy is well protected no matter what the objectives sought by the government are.
Conservative Party's Mr. Decker.
Thank you, Mr. Chair. Bonjour, Monsieur Terrien. Bienvenue. Félicitations.
Welcome and congratulations, Mr. Terrien.
You mentioned a few things that you'd like to see changed in Bill C-13. One of your comments was that you would recommend that the bill be split into two parts, so further study could be done. And frankly, we've heard that from a few witnesses. Have you followed the debate in the House of Commons on this bill?
To some extent, not as closely as my colleagues, but to some extent. Yes.
Okay. Your colleagues certainly can inform you on that, and I presume have. Are you familiar with the testimony that's been provided to the committee in the last several meetings of the committee on this subject?
Some, but again, my colleagues would be better placed.
Well, I can fill you in. So there have been 12 hours of debate in the House of Commons on this bill so far. It includes 21 members of the New Democratic Party, which is more than 20% of the caucus. It includes 11 meetings, including today, of the committee. That's 22 hours of study in the committee. So the total is 34 hours of debate and study. The committee has heard from 21 special interest groups, 10 victims or victims groups representing victims, the police, professors of law, the Canadian Civil Liberties Association, the Canadian Bar Association, the Criminal Lawyers Association, the University Teachers Association. I could go on. I think you catch my drift. Who else would you recommend this committee hear from? And I can tell you that virtually all the witnesses requested by all parties have been heard from, including yourself. And how much more study do you think should be required on this bill and the investigative powers provisions of this bill?
Thank you for the question. So, Mr. Chairman, from the list that you described, I readily accept that there has been a serious examination of this bill. At the same time, I see that many people who appeared before you have suggested that the bill be divided. And I would suggest that it is perhaps, for the reasons I alluded to earlier, that although there have been many sessions on the principles, and perhaps more than the principles, there is, I think, a need for a more fulsome discussion about the practical impact from a technical perspective of this legislation, so that parliamentarians and Canadians can know precisely what kind of information would be disclosed through things like voluntary disclosure and so on. So it's more of a technical discussion on the practical import, so that parliamentarians and Canadians can have a more informed conclusion on this bill.
I asked the same question to the Canadian Bar Association, and they had no suggestions on who else we should hear from. And I can tell you, sir, that each of the points raised in your comments about your concerns have been raised by several witnesses on several occasions, including all those special interest groups and law professors that I mentioned. Are there any other aspects of this bill that you want to tell us about that haven't been mentioned either in the House of Commons or here at committee?
No, I think it would be useful to have law enforcement agencies perhaps explain and telecommunications companies explain the practical import of what is before you. That essentially is my message.
Okay, so on Thursday, May 15th, you may know that the committee heard from the Canadian Association of Chiefs of Police by Mr. Jim Chu, who is the Chief of Police of Vancouver, the Ontario Provincial Police, the Royal Canadian Mounted Police, and the Halifax Regional Police. And each of those agencies told us these investigative powers are necessary as drafted to allow them to properly investigate cyber crimes. Are there any other police organizations you think we should hear from?
If I may, thank you for the question. I think certainly the information that the police associations have provided provides one slice of the picture. The other information that you heard through previous committee hearings was the fact that the Internet Association representing organizations actually collecting the data feel that the data is so sensitive that a higher legal threshold is required. And so from that perspective, our view is that given that these organizations are the ones collecting it, they're the closest to it, and they understand the sensitivity the best.
So the Internet Association was here, and they did make those comments. Mr. Therrien, are you familiar with the Cybercrime Working Group report on cyberbullying?
I am not at this point.
Okay. Well, I'm sure your officials are. It was made up of experts representing each of the attorneys generals of each of the provinces and territories. And in June 2013, they issued a report called with respect to cyberbullying and non-consensual distribution of intimate images, dated June 2013. And they said the following. They said, cyberbullying occurs in cyberspace, and the electronic evidence needed to obtain convictions of cyberbullying must be obtained from Internet service providers, content hosts, and other social media services. The ability to preserve and obtain such evidence is crucial to every online investigation, and currently Canada's investigative powers are not robust enough to address the demands of cyber investigations. In this regard, Canada lags far behind its international partners. Now, they made a number of recommendations about investigative powers in recommendation 4 of the Cybercrime Working Group. Are you familiar with the recommendation 4 or any of the recommendations of the Cybercrime Working Group?
Not at this point.
Okay. So I can tell you that it includes data preservation demands orders, new production orders to trace a specified communication, new warrants and production orders for transmission data, and other amendments to existing offences, investigative powers that will assist in the investigation of cyberbullying and other crimes and that implicate electronic evidence. So, sir, we are implementing the Cybercrime Working Group report. These are experts from each of the provincial attorney generals saying this is what's needed in our criminal code to properly investigate cyber crimes like cyberbullying. And without these, they say the cyberbullying provision of non-consensual distribution of intimate images would be a toothless power. Do you agree or disagree with them?
A fairly quick answer.
I would repeat that we are in favor of legislation modernizing techniques. My understanding is that the group in question, although they were recommending to modernize legislation on transmission of data, preservation of data, etc., did not make any specific recommendations on the legal thresholds, for instance, for accessing data. And that is a key point that I think warrants further review.
Okay, thank you very much. Thanks for those questions, those answers. Our next question from the Liberal Party is Mr. Casey.
Thank you, Mr. Chair. Mr. Commissioner, I think it's been made pretty clear to you that the government has no intent of splitting the bill, as you and many other witnesses have suggested, and certainly that last line of questioning would confirm the government's attitude on that. You, sir, sent a letter to the committee yesterday and said that if the government isn't inclined to split the bill, that one of the things they should do is to incorporate a statutory review on a regular basis. And I know that you've had the opportunity to have a look at the amendment proposed by the Liberal Party that suggests that very thing. So my question for you is what advice you have for me or for the committee with respect to that amendment, given that it appears to be entirely consistent with what you wrote to the committee yesterday.
Thank you, Mr. Chair. I actually have not seen the exact language of the motion, but absolutely, as we said in our submission filed before the committee yesterday, we are of the view that if Parliament decides not to divide the bill, which would be ideal from our perspective, the next best thing would be to adopt a clause which would require a parliamentary review of the new statute after a period. We suggest 5 years. I don't know what your motion calls for. Certainly in legislation, when legislation was amended in other countries in Europe, for instance, government authorities found after similar legislation was adopted that there were amendments to be made after the fact, that certain lessons had been learned, and it would be useful to have a clause requiring parliamentary review after a certain period so that these lessons are learned and are the subject of parliamentary debate and possibly amendments after a certain number of years.
Okay, thank you. The amendment that's been put forward actually calls for a comprehensive review of the provisions after 3 years. Would you find that to be unreasonable?
That is not unreasonable at all.
Thank you. Another thing that you referred to in your opening remarks and also in your letter of yesterday is something that we've talked about a fair bit at committee, and that is the lack of transparency reporting by telecommunications companies. So we heard that it's actually the norm among internet providers, and Facebook has a robust transparency reporting requirement. And you said in your opening remarks that there are no requirements in the bill to report on the extent of the use of any new powers. Again, the Liberal Party has proposed an amendment to the bill to require that a person engaged in providing telecommunication service to the public shall, respecting the requests made by peace officers to voluntarily preserve data. This is the data for which they are going to be given an immunity. That they submit an annual report to the minister, if you will, a transparency report. Your view on that proposed amendment, sir?
We would agree that a requirement to report would be a useful addition to the legislation. We have referred in our submissions to an example of a report that is currently done, that has been done for quite a while, since 1977, I understand, on electronic surveillance. That kind of report we think would be very useful. It is quite detailed on the types of crimes for which it is used, the types of methods that are used, that would enhance transparency significantly.
Okay. And again, Mr. Commissioner, very much appreciate your comments and your point of view with respect to the immunity that's proposed in Section 487.0195. This is something that, again, we've talked to a lot of witnesses about. And the one thing that has confused me, and even after all of the debate and all of the evidence we've heard, we still haven't found one person, one organization who said this immunity is something we were asking for. But to your point earlier, we haven't heard from telecommunications companies in spite of all the time that we've spent. So your position with respect to the immunity that's been granted for the non-consensual distribution of subscriber information without a warrant, your recommendation is that that immunity not go forward, that be deleted, or that it be clarified or changed. Do I have that right?
Yes.
Okay. And what would be the impact if it was deleted? Because, as you know, we've proposed an amendment to delete that immunity. We have heard from the minister, and we've heard in questions from the Conservatives that the immunity doesn't really mean much. It's already in the code, which begs the question why they put it there in the first place. But your view on what would happen if it was simply struck, as we've suggested?
Well, one of our concerns with the immunity clause or the amendment to the immunity clause through C13 is that it takes away a current requirement that immunity exists in the course of investigations, and that is no longer the case in the clause being proposed to you. So that, to us, is a concern. Certainly, to broaden the immunity clause sends a strong signal to telecommunications companies to enhance the kind of voluntary disclosure that is currently occurring, and that, to us, has serious privacy implications. So if the purpose of the clause is essentially to codify what existed, the status quo, so to speak, why is it needed? And if it is adopted, it does seem to send a signal to enhance, to augment voluntary disclosure, something that we are concerned with for privacy reasons.
One more minute, Mr. Casey.
And can you help solve this mystery? We have not had a telecommunications company or a telecommunications industry association appear before the committee. We have not had anyone who has said we've asked for this immunity. Can you help us understand who wanted this? To your knowledge, is this something that the telecommunications companies that we haven't heard from, is this something they were asking for?
I'm still new to the job. I don't know, but perhaps one of my colleagues can answer that question.
No, I don't think we have any personal knowledge of their position or who actually requested or that the immunity clause be amended in this way.
Nor do we. Thank you.
Thanks for those answers. Our next question from the Conservative Party is Mr. Seaback.
Thank you, Mr. Chair, and thank you, Mr. Therrien, for giving us your views on this, which is important. We've heard lots of competing views on this legislation, particularly with respect to transmission data, the scope of what's included in transmission data, and of course what the standard should be to access transmission data. And I think that's what you get when you do an in-depth study like this. You get those competing views and those competing voices. When you talk about transmission data, what you said in your opening statement was that, and I'm paraphrasing to an extent, transmission data equals personal data, and that's why you believe it should be only accessed at the higher threshold of reasonable grounds, right? To believe.
Yes.
Reasonable and probable grounds. Now, we had the RCMP and various other police officers here at committee. In their testimony, they said, transmission data is very precise, contains no content on transmission, it does not reveal substance, the meaning, or the purpose of the communication. It more or less identifies a type direction data, the date, duration, and so forth. So transmission data is actually a very narrow snippet of metadata. Would you not agree with that, or do you disagree with the police?
I would say that transmission data goes beyond information that was found in the old phone books. So it has that, but it has more than that. It may not have the content of conversations, which is a good thing, but it has information about location of individuals, sites being consulted, several types of information that are way beyond what was found in phone books that I do think is personal data and deserves higher protection.
You don't agree with the
suspicion.
You don't agree with the police, though, when they say it's very precise. You disagree with that. If I'm summarizing, you think it's much more than that.
It's more than phone book data for sure, and it contains important, sensitive, personal information.
But you're okay. You would be okay if it was at a different threshold, right? Which was reasonable and probable grounds.
Yes.
Then you're okay with that.
Yes.
You're clear on that.
Yes.
But then you also said in your statement that this should be the standard unless a case has been made to, as in your words, lower the standard. So if you think a compelling case was made, then reasonable suspicion is an okay standard.
Mr. Chair, that goes back to the suggestion that I'm making for further review of the specific details of what this bill entails from a practical perspective. You're referring, sir, to testimony by the police, which tends to understand the definition of transmission data in a very narrow way. I don't doubt that that is their perception, but we think that transmission data does include, again, some elements of sensitive information, and it is exactly that point, I think, that deserves further examination.
I understand that. So we heard from all kinds of people. We heard from the RCMP, we heard from the OPP, we heard from the Canadian Association of Police Chiefs, we heard from the Halifax Police Chief, we heard from victims who are also lawyers, and they all said clearly and unequivocally that the appropriate standard for obtaining transmission data is reasonable grounds to suspect. So I take it what you're suggesting is all of those people who have come to this committee, they have not made a compelling case that we need this information, despite victims groups, police officers, all these people are saying we need this. You're saying that's not a compelling case.
I have not, I must admit, read their testimony being new to the position. I do think that there are issues that still require some examination, and perhaps Madame Cossem would like to elaborate here.
Thank you for the question. Yes, there were many witnesses, as has been pointed out, that have testified before the committee, and quite a number of them as well have advocated in favor of the higher threshold. So in fairness, there are competing views here. And one area that I think would benefit from greater light would be the viewpoint of expert technologists who, even internally in our office, we were having discussions right up until this morning about the technological implications of transmission data and how to contain it in a way that is attempted to do so in these amendments, but is very difficult to contain in real concrete terms. And I think this is what the kind of study that was being suggested is a more practical, concrete examination of the data elements when put together in the aggregate over the long term and amassed over aggregate periods of time and volume, can reveal much, much more personal information.
Okay, but to go back, so what you're saying is you disagree with the police that they need these powers, that they haven't made in your minds a compelling case to have these powers, correct? I mean, that's what you're basically saying. Yeah, I mean, this is sort of a yes or no.
If you don't mind, it will be just a little more than yes or no. We agree that the legislation on techniques needs to be modernized. We do think, though, that there is a need for further study, again, on the practical consequences of what is before you. That is our position. And
do you have
in
a
the
precinct?
meantime, until such time as this further study is completed, we err on the side of reasonable grounds to believe. It is possible that some case can be made for some transmission data to be accessed on a lower threshold, but absent that demonstration, we err on the side of reasonable grounds to believe.
A police officer or a Crown attorney to
You don't need
investigate and
to-
prosecute these types of
That
cases?
is Mr.
have not.
Seaback's time. Thank you very much. Thank you, Mr. Seaback. Thank you for those questions and answers. Our next question from the Democratic Party is Madame Papay.
Merci beaucoup, Monsieur le Président. Merci beaucoup.
Thank you very much, Chair, and thank you, Commissioner, for being here. I just want to echo what my colleague has said. It's wonderful to have some hours of debate in the House and in committee, but I do think it's important to mention that the experts, for the most part, agreed that the consideration of this bill should perhaps have been done in greater depth. And unfortunately, that hasn't allowed us to take into consideration other provisions in other bills like S4. I think that despite the fact that we've done a good study, perhaps it could have been done in greater depth, taking into consideration other bills that might have an impact on the enforcement of C13. My first question, with respect to your presentation, you spoke about a lack of accountability mechanisms. And C13 does not have any type of mechanism for oversight, either with respect to notification about information for the person whose data has been shared with a third. So 184.4 of the Criminal Code has been considered by the Supreme Court. It deals precisely with the issue of the application of that bill, which did not contain any type of mechanism for oversight, and people who were being watched by the police, monitored by the police, weren't aware of that fact. And if you look at 188, which provides for a rapid approach by a judge, because there was a surveillance, an oversight mechanism. Now, can I ask you this? Can you shed some light on this matter, but how does it respect the Charter of Freedoms and Rights, and how is this seen in the context of a C13? We are clearly in favor of such a mechanism, but in terms of the judicial question, the legal question that you were asking, I'll turn to my colleague. Excuse me, I will let Ms. Brady have time as well, but I will begin. I just want to mention that, yes, the amendments that have been made to increase the accountability and transparency under the terms of the clauses that you have mentioned are in fact good news. I think this is a good example of change to improve transparency. The goal is certainly valid. This is a type of model that we feel could be emulated in this case to provide greater transparency and accountability, and to also provide a possibility of pursuing the greater goals of the legislation. But perhaps Ms. Brady would like to add something. would you have an example of an oversight mechanism which might constitute something valid at the level that you have quoted? The court's authorization, which is very important. But what we're talking about today is the threshold that has to be assessed, and it is very important. But the fact that there is the involvement of the court is a major factor. The type of report that we would consider, well, this would involve greater transparency and accountability. For example, shedding light on the scope and the breadth of these practices on a daily basis, so Canadians are aware. In your presentation, Commissioner, you spoke to the threshold for obtaining a warrant rather. You said you used examples that of what the police have to provide, and the issue being either reasonable suspicion or reasonable and probable grounds. In the case that we are studying now, in your opinion, to obtain a warrant, should the criteria be moved up? To obtain a warrant, should they be more stringent, or should you just preserve the data? Should there be the same criteria for criterion for everything? As I explained in my opening remarks, on the issue of the preservation of certain data, the reasonable grounds for suspicion should suffice, because you want to have data that may well be useful in the context of an inquiry. But the problem for us is the access to sensitive elements of information that might be disclosed. It is at the point of access, at the moment of access, that you have to believe rather than suspect as this threshold. Okay, so this bill contains no section, no clause, for example, with respect to the destruction of data. Does that tie into reasonable suspicion? The person wouldn't be notified. Do you think that this should be added? That is to say that that this should be added to protect the privacy of an individual. Well, with respect to conserving the evidence, it should be preserved for a certain period and thereafter destroyed. But in terms of access, we are talking about something different. I don't know if my colleagues would have any comments about the destruction at that time, but my understanding is this: by its very nature, the evidence is destroyed at the end of the time period.
Answers. Our next question from the Conservative Party is Mr. Decker.
Mr. Therrien, you have mentioned a couple of times the provision, the so-called immunity provision in the bill, 417.0195, I believe it is. Are you familiar with Section 25 of the Criminal Code of Canada? Okay. And are you familiar with some of the case law under Section 25, including, say, the decision in R.N. Ward, the judgment of Mr. Justice Doherty of the Ontario Court of Appeal?
No, I'm afraid not.
Are you familiar with the Spencer case that Madame Boivin?
In general sense, yes.
All right. We previously heard from Mr. David Butt. He represented the Kids Internet Safety Alliance. He's a former prosecutor, has argued many cases before the Supreme Court of Canada. And he said a number of things about the bill. He said, we should all ask precisely what pre-existing privacy rights does Bill C-13 take away? And the answer is precisely none. He went on to say, the bill does not expand police powers to obtain information without a prior court order, so any suggestion that C-13 authorizes more invasive, warrantless cyber snooping is an urban myth. Specifically on the point of Section 25, he said, the police ask ISPs to provide voluntarily information about can they ask voluntarily about information about the internet profile? Again, very little, just a subscriber's name and address. That is all. It was his view that this bill and that provision that we're talking about simply codifies Section 25 and the case law. Do you agree or disagree with that?
I would go back to the view I expressed earlier, that is that this provision we find would actually send a signal to telecommunications companies to voluntarily disclose to law enforcement agencies more information that is currently the case. And our view is that this kind of activity should take place under defined parameters, under clear legal thresholds, with transparency mechanisms and with reporting mechanisms. And the concerns we have with this particular provision is that it lacks these standards or safeguards that we think are very important.
So the Department of Justice officials appeared before our committee and they made the case that Section 25, taken with case law and Arn Ward and other cases, simply codifies and does not expand the law on this point. Do you agree with the Department of Justice officials?
Kassem to answer this, please.
Thank you, Mr. Chair. Thank you for the question. There are two competing views on the impact of the immunity clause. One is that it is inserted for greater certainty, and in fact it doesn't change anything. On the other hand, a competing view is the question that's presently before the Supreme Court right now, and that is whether this immunity clause, the current one, creates a new source of lawful authority for the purposes of PIPEDA, our enabling legislation.
So you would agree that it is arguable, and it is an argument that many people hold, that this provision does not expand the law.
We argued that, in fact, it should not be interpreted or applied that way. In that case, it was actually interpreted and applied in a way to create new source of lawful authority. And so those are the two competing arguments before the court, and we will await their decision to see what the outcome is.
Fair enough. So will we all. Now, are you familiar with the testimony of Mr. Gilhooly, who testified before the committee a few weeks ago? So Mr. Gilhooly is a former corporate counsel. He was also a victim. He formerly, I believe, was corporate counsel to a large media company. And when I asked him, without this provision, and he were advising his client whether or not they should comply with a police request, his response was, as corporate counsel, my job is to protect the client, and so I would advise not to disclose. And just so you know, I too was in that position many times, advising corporate clients, and I can tell you my instincts would be to do likewise, to not disclose if there was any possibility that the company could be held liable criminally or civilly. What's your comment on that?
I think fundamentally the issue boils down to the lack of clarity around what the provision in PIPEDA 7.3c.1 amounts to in practice. And so, in our view, the current protection against liability in Section 25 is probably sufficient, and the best source for directing energies toward clarifying the law would be better interpreting 7.3c.1.
I would say in response, as former corporate counsel, I disagree with you. So did Mr. Gilhooly, and so would I think many other corporate counsel. So, Mr. Therrien, I would like to ask you about the time required to obtain a search warrant. Mr. Butt, in his testimony, said to the committee, he gave us an example, and he said if we had to go to get subscriber name and address, which he contends is what is generally provided by internet service providers when requested by law enforcement, that if we had to do that via a search warrant, it would take a routinely 60 days to do that. How quickly do you think investigators need to obtain the information about who sent the cyberbullying message, perhaps with an image attached, in the internet age? How quickly do the authorities need to act, in your opinion?
Mr. Commissioner.
I don't know the exact time period. I will say that preservation orders are meant to protect that period to obtain that information. I don't know if my colleagues have anything to add further to that, but that's what preservation orders are for.
Thank you very much. Thank you for those questions and answers. Our last questioner is Mr. Jacob from the New Democratic Party.
Merci, Monsieur.
Thank you very much, Chairman. And thank you for our witnesses for being here with us today. My first question is to the Commissioner. In a recent statement that was made here in Ottawa on mass surveillance in Canada, and it was signed by numerous professors and organizations, it states that the powers of provincial and federal privacy commissioners should be commensurate with the quasi-constitutional nature of privacy law. Do you agree with this type of statement? I'm certainly in favor of significant powers for privacy commissioners, and given the quasi-constitutional nature of the work, super. And do your existing powers and resources allow you to adequately protect Canadians' privacy? Perhaps you will allow me not to answer. I will ask Ms. Kassam. It's only my third day at work in this job at the office. I'm very new to it. I've got a wonderful team that supports me. And is the team strong enough? Certainly. In 2010, your office published a guidance document called A Matter of Trust, integrating privacy and public safety in the 21st century. An analytical framework for assessing privacy and security measures was developed to ensure balance. In your opinion, do the provisions of the bill that we are dealing with, C-13, do they respect the rights guaranteed by the Canadian Charter? I haven't done an analysis about the constitutionality of the bill, but this morning we have shared concerns that we have with the privacy matters, and I think I will just leave it at that in terms of answering your question. All right. Do you have any suggested changes on a priority basis? What would you propose to the committee? We have 4 concerns, and we've shared them with you. I think that the legal immunity is very important, and it should, in our mind, be withdrawn or amended, as we indicated in our written responses yesterday. And also the matter of accountability is very important. So, how much time? Oh, do you agree? And if you do, why? With a study that was carried out by the Privacy Commissioner of Alberta, British Columbia, and Ontario, who said that C-13 will entrench and possibly encourage the expansion of warrantless disclosure of private sector data to law enforcement by providing broad immunity for such practices. Well, each commissioner certainly has his or her point of view, but the cyberbullying, the creation of crime, is something that needs to be dealt with. What you have here is a good thing, as I have indicated, but there are certain measures in terms of modernization of the investigative tools that have to be looked at, and herein I agree with my colleagues.
and supporters. Thank you for joining us today. We are going to go to clause by clause after this. Mr. Commissioner, I understand, based on my reading, that you've had 32 years of experience in the public service, so most of people after 32 years be looking for retirement. Congratulations on your retirement job as the Privacy Commissioner of Canada. Welcome and congratulations on that appointment, and good luck in the future.
Thank you. I don't see that as retirement at all. I intend to be active. Thank you.
Thank you. We're going to suspend while we get ready for the next piece on clause by clause.